Look at that. The world did not end yesterday.
It didn't.
Or this morning. However, you were real late, Harris.
I was late.
Attorney time, huh?
Attorney time, Greek time.
I think Greek time. You are an attorney. You represent people across Illinois and Indiana. People are still buying houses, right?
100%. Yeah.
And selling houses.
Yep.
I think we branded this episode I dated the rate, I married the house, and now I need to blank my spouse. Blank could be a lot of things. And I think it's wild to me that the comma after your name in the following 2 to 4 words can have massive impacts on the disposition of your home later on. Whether you are burying your spouse, divorcing your spouse, marrying your spouse isn't really marrying your significant other, turning them into a spouse. But that comma and those words mean a lot, right?
Huge.
Particularly in Indiana and Illinois that don't have your standard community property rights or community, whatever you want to call them.
So, yeah, I mean, I deal with this all the time. People will call me, say, hey, my mom passed, dad's still alive. They were both on the deed. We want to sell it. Well, okay, how did they take title? If nothing was specified, they took title as tenants in common, which means that 50% interest of the mom that passed now goes through the estate. And so that can open up a lot of issues if you want to sell. For example, all the heirs now have to sign off. So the father and any kids. Then you have to see, are any of the kids deceased? If they are, did that deceased child have children of their own? Okay, let's say they did. Are those children over the age of 18? No. Well, a minor cannot sell real estate.
No.
So you have to get a guardian appointed by the court. So now what could have been very simple transaction had there been joint tenancy or tenants by the entirety specified on the deed now opens up a whole can of worms. I'm actually dealing with one right now where there are 5 children and a few of them are in Mexico. They don't know if they're going to be willing to sign a deed. We also would have to get them to go to the embassy or the consulate to be able to get it notarized. And, so now what could have just been, one document signed and notarized by the surviving spouse turned into a whole fiasco where, I don't know what's going to happen now. They have to figure it out amongst themselves.
It's always interesting when you shake the family tree too, because you never know. Maybe you always find dad's other kids.
Yeah, well, I'm dealing with another one in Indiana right now. The son, both parents died. The son wanted to sell the property. Well, I looked. There was no transfer on death deed, no will, nothing like that. And so now it goes to the heirs, and there's 2 other heirs along with him.
All right.
One of them is incompetent, ruled by a physician in the court to be incompetent. He has a guardian.
So now you have to
sell. Well, the guardianship doesn't cover selling of
real estate.
The real estate, yeah, it only covers his medical issues and his person. So we have to go back to court, establish guardianship for the transaction, and now we can finally sell. So this all could have been avoided with some simple, either few words after their names on the deed or a transfer on death instrument.
So I've seen transfer on death instruments frequent in Indiana.
Mm-hmm.
Is that also possible in Illinois?
Yeah, I'm dealing with one right now. Actually, a client called me yesterday. 100% doable. Illinois, it's a little bit. You got to be a little bit more careful. There's a little bit more that you have to watch out for because of the homestead rights in Illinois. A spouse that's not on title, if it's their primary residence, they still have to sign off on a deed. And that would also include a transfer on death instrument. So they have to waive their rights to the homestead.
You got to waive your rights. Beastie Boys, you got to fight for your rights. And you never know on there. So let's talk about this real quick. So there's 4 versions of tenancy. Is that right? 3?
Tenants in common, which is the one we're talking about where it goes through your estate. We have joint tenancy where basically everybody on title has survivorship rights. One of them passes, their interest in the property just gets distributed amongst the remaining people on title. And then we have tenants by the entirety which is just like joint tenancy, but it's specifically for married couples. And there's limited asset protection or creditor protection as well.
All right. So let's talk real quick. So joint tenancy, you're married, or do you have to be married for joint tenancy?
No, anybody could be a joint tenant.
All right. So you and I buy a property, you pass away, I'm 100% owner.
Yes. Only thing that needs to be established, as long as the joint tenancy wasn't severed by some, something
Weird,
during the
yeah.
time,
Okay.
assuming it's still valid. Yes, all that would need to be done would be, we would need your death certificate, and we would need an affidavit of survivorship to be recorded, where we tell the county and everybody puts everybody on notice, hey, we were joint tenants, this person died, here's the death certificate, I am entitled to his interest.
All right. Then we have tenancy by the entirety.
Yeah, same thing, but for married people.
Okay.
Yeah, adds a little bit of creditor protection.
All right. You got to stay away from those creditors.
Yeah.
Those darn lenders, I'll tell you. And then the last one.
Tenants in common. That's the one that can open up the can of worms, where somebody passes, it goes to their estate. You got to figure out who the heirs are. But there are times when tenants in common makes a lot of sense. I mean, if you want to do different percent ownerships, you have to do tenants in common. Joint tenants, you have to have the same interest.
All right. So, and this matters. So in Illinois, and I believe Indiana is the same way too, right? If all of a sudden we're going through heirs, and then we're probably involving potentially probate, or I know in Illinois we can do bond in lieu of probate to sell a property sometimes. Does that exist in Indiana too?
Mm-hmm. Yeah. So there's a lot of,
obviously you're very familiar with title as well. So let's talk about some of these costs.
For sure. I mean, if everybody's on the same page, then you can do a devolution affidavit in Indiana. You have to wait 7 months from the death of the deceased person in order to give everybody time to basically, all the creditors to say, okay, he's dead, and go after him if they want to, and all that kind of stuff. But yeah, 7 months later, you can sell the property, transfer the property, whatever you want, along with a devolution affidavit, assuming all the heirs are willing to sign the deed, because they have to sign their interest, basically.
Okay.
In Illinois, same thing, a lot shorter time frame. I believe it's, if I remember correctly, 45 days after the death of the deceased person, and then you can do basically the same thing, affidavit of heirship.
All right. What about trust? We hear frequently, oh, I want to put my property in a trust, which is a very general term, but a lot of times, like in Illinois particularly, we have the Illinois Land Trust as a vesting, which, to my understanding, I'm not an attorney, you are, that's why we're here asking you the questions, it converts real property to personal property. Is that kind of like the concept of it? So
a land trust is just it's the same thing as a regular trust, specifically for real property. That's all it is.
Okay.
And it's an institutional trust, typically held by Chicago Title, a bank. Those are the big ones.
Yeah, and it masks your name from public record.
Anonymity, for sure. Okay. And so it's great if your main asset is real property, and that's what you want to basically protect and be able to remain anonymous for, and be able to designate beneficiaries for, successor beneficiaries, and things like that. And it's a lot cheaper than a regular trust. So, my fee for those are $250 to prepare everything, and then the land trustee will charge $300, $500, $600 to set it up.
Lenders hate them.
Yeah, lenders typically won't lend into a land trust. I do know regular trust they will, as long as correct language is. You have to run it by the underwriters.
And land trust we do them, but there's an extra 18 pages.
Yeah,
because obviously we have to make all of the vesting match, and then with the land trust, one of the craziest parts about it, right? You have to bring the mortgage to the land trust office to have them sign that document.
Yeah, because I've never actually had one where it's been financed directly into the land. I've had people transfer into a land trust after closing, which has its own risks, but I've never had it where somebody's actually purchased in a land trust and gotten a loan. So I would imagine there's a personal guarantee on there.
Yeah. And I think that's one of there's a lot of misconception in our world, and I'm sure it probably flows over into your world, about how we how we invest things, right? As the non-qualified mortgage, the debt service coverage ratio, and a lot of these investor loans have come out. Oh, I want to take title in my LLC.
Yeah.
And it's like, well, you're still personally guaranteeing that. You, Harris, as a human, as Harris individually, 98% of the time is signing that note, obligating yourself to the
Well,
to
and the
that.
mortgage too, which is going to be recorded. So like, if you want anonymity on some of these things, you know,
It never ends, right?
Yeah.
So we're covering why that comma matters. So you're representing me throughout a real estate transaction. You get the contract, you go through attorney review, inspection, all that stuff, and then you're reaching out and going, "Hey, Tony, you're married. How do you are you and your wife taking title? How do you want to take title?" Is that kind of the flow of things?
Yeah, if I'm on the purchase side, typically whoever's on the contract will be people on title, unless we do an amendment later. But yeah, I need to find out if they're married, if there's multiple people on the loan, are they married to each other, married to someone else? How do they want to take title? Kind of explain to them the difference. Most people opt for joint tenancy or tenants by the entirety. It just makes more sense in most situations. However, there are times when people are like, no, I want to do tenants in common because reasons.
All right. And then the other side of the equation. So we've kind of talked about the either marrying a significant other, turning them into a spouse, and then buying the house. Divorce in real estate. I think divorce rate probably the highest it's ever been. Probably going to go up today, a little higher. Never know. The world's a little bit crazy, but talk us through. I know you don't really represent people in divorce cases.
No, I don't have the stomach for that. I don't know. Major props to the divorce attorneys. I could never do it. Too much drama for me.
But I'm sure as you're dealing with disposition of real estate,
Yeah.
The judge says, "Hey, if you don't refinance this property by this time, we're putting this up for sale." And I guess I don't know if you could talk really quickly on it. Does it matter if people are on title in Illinois or in Indiana? Does it matter if it was a primary residence? Is there other restrictions that might give a non-title holding spouse equitable rights at all?
For sure. I mean, especially in Illinois, like I said, we have homestead rights. Basically, whatever the court determines the split is what has to happen. I'm actually dealing with one situation in Country Club Hills where they didn't follow the divorce decree, and now the ex-husband's going for bankruptcy, foreclosure, and the ex-wife is kind of on the hook for a lot of the stuff. She signed the mortgage, so what should have been taken out of her name, refinanced, all that kind of stuff is not, and now she's dealing with it, and the guy doesn't really care because his credit is gone anyway.
Already in the crapper.
Bankruptcy, so he doesn't care about a foreclosure, really. So yeah, for sure. The issue I run into more is when people want to purchase while they're in the middle of a divorce, which is not a good idea.
Yeah, that makes us that makes us cringe on our side as well.
Right.
So walk us through the risk on that.
Yeah, well, I mean, until you get the final divorce decree, you're not divorced. So anything that happens up until then can still be part of the settlement. So if you buy a property during that time, your soon-to-be ex-wife or ex-husband may be entitled to it, which is why lenders won't lend on it unless there's a settlement agreement before the decree or it's actually officially done.
Oh, lenders won't do that? I hear all the time about all these lenders. They always do that. I'm like, it's actually, we deem it on our side an infinite risk.
Yeah.
Because you just don't know what's going to happen. It could, right? If you're not, until you're actually divorced, you're not divorced. So you have money that may have been in the marital pot that came out for that. You have potential for child support, all these other things.
Yeah, it's a lot of issues. So yeah, and then they'll say, well, what if I have my sister buy it for me? And then, if you're buying cash, that's fine. If it's going to be an investment loan, that's fine too. But if it's going to be a primary residence where she's saying this will be my primary residence, but really it's for you, well, then you run into some mortgage fraud issues. That's a straw purchase.
Mortgage fraud, occupancy fraud is the number one case that's being investigated right now by every agent, not just like Fannie Mae and Freddie Mac, but the FBI, HUD. Misrepresentation of occupancy and intent is a crazy situation right now. And if you're dealing with a mortgage company that's not willing to have that honest conversation with you, because the idea of, I might get a little bit lower of a rate or a little bit better loan terms,
right.
I promise you that these loan servicers and everyone else is checking to see if you're changing a forwarding address on your mortgage statement, and it'll be oh, you're not Harris.
Right. Yeah. So definitely have to be careful with all that. And I typically, if somebody wants to do all that, I just say, find someone else. It's not worth the risk on my end either. So a lot of people don't realize the risk. They think nothing's going to happen. And I'm sure a lot of cases, nothing does happen, but I wouldn't want to roll the dice on that.
Me either. It's it can be expensive. It's I think on the disclosure that says the fraud hotline, it's 30 years in the clink and $1 million fine.
Right.
I don't think you're doing 30-year bid.
Nope.
I could probably afford to. I could 3 square meals and maybe work out a little bit in rec time. But all right, so we've covered. All of a sudden, I'm blowing up. We've covered how to take title, what it means from marriage, from death, from divorce. I don't think there's any other real situations there. We talked generally about trust. I think a lot of people love the idea of a trust, but you alluded to it being expensive.
Yeah. Trust, unless you find an attorney to do it for very cheap, which then you have to kind of think, is it going to be good?
Yeah. Is this the Walmart
right.
version?
Full trust don't always make a lot of sense for most people unless you have enough assets to make it worth it, in my opinion. A lot of financial institution accounts can be payable on death. They have designations for payable on death, so you can do that outside of a will or a trust. And then if your main asset is your house, I mean, a land trust is cheaper. So, you just got to really weigh the benefits of how much is it going to cost me? How many assets do I have? How much control over the disposition of the assets after death do I have? Will a will just, especially now when they have unsupervised probate.
That's what I was going to say. You're going to say will a will. So let's talk through that really quick. So you have unsupervised probate. Tell us about that.
Yeah,
how do we get there?
That's really easy. If you don't have a ton of assets, everybody's on the same page. The court will just say, here, this person's going to be appointed. Figure it out. We're not going to look over you. Do whatever the will says, and you're good. Whereas then you have supervised, where now you need court approval for everything. They're going to look at everything, make sure it's all done according to the will and all that kind of stuff.
So if someone passes away in your family and they have a will, you usually need to present that to the county. Was that kind of the case, or what happens in that process?
Well, if it goes through, if there's a will, then it has to go through probate, and then it just determined. It depends on whether it's supervised or unsupervised. Either way, you're getting signed off by the court. Just how much oversight from the court is there?
And then without a will,
it goes through intestacy, and it just goes according to the intestate laws of whatever state you're in. And so, for example, if you have a spouse and 2 kids, spouse would get half your interest, kids would split the other half, so on and so forth.
All right. Your office takes care of some of this stuff. I know you say you do land trust.
I do land trust mainly, do simple wills. I am speaking with another attorney on actually tomorrow, so I'm really excited for that. He's very, very experienced in probate and estate planning. Maybe joining the team. I don't know yet, but if that happens, then I'll be able to offer a lot more services.
That is fantastic. Yeah. What else are you doing?
Business formation, business sales. If you want to buy or sell a corporation, LLC, whether it's a stock sale, asset purchase, anything like that, could definitely help with that. If you want to form a corporation, form an LLC, I do pretty much all of that except for nonprofit organizations. I don't really touch any of that kind of stuff. But
you're for the profit. I love it.
Yeah, I just don't know. I've never done them before.
I'm sure there's a lot of technicalities in that stuff.
I'm sure there are too, so that's why I don't touch them.
I love that. All right. I think the most unique part about you and people that live in our area kind of grasp it, but maybe don't understand, is you can practice law in Illinois and Indiana.
I can. Yep. So I do both. Majority of my business is Illinois, but I get a lot of dual licensed agents using me for deals over here. I can do a lot of investors over in Indiana as well that want to do land contracts, seller financing, things like that. So I'm able to do all that kind of stuff and offer a one-stop shop for both states.
How do people get in touch with you?
You can call me on my cell phone, 219-671-6347. You can reach out to me at harris@kouklakislaw.com and
better spell that one.
at kouklakislaw.com. That is KOUKLAKIS law.com.
And you can swing by your office there in Maryville.
Yep, 2290 West 81st Avenue, Maryville, Indiana, or 15,000 South Cicero Avenue, Suite 300, Oak Forest, Illinois.
Fantastic. If you do go to his office in Maryville, hit up Simon Says first. Get your hands nice and greasy. Wipe them all over his furniture over there. He loves that.
There you go.
Harris, appreciate you hopping on, talking about all of the fill-in-the-blank situations that you may have to do with the spouse or any other family member. If you guys are watching this, going through this, if you have a family member that has passed away, is very ill, end of life, or new life, and you want to put a simple will together, any of that stuff, get in touch with Harris. He will walk you through it, make sure that you're set up properly so that you're spending that little bit of money today to protect your ass. It's later on. I love it. Harris, thanks for hopping on.